Welcome to What to Do When, a podcast from real lawyers with real perspective, where we explore a variety of legal issues and scenarios. Each week, we focus on a new topic and discuss what to do when and if any of these legal scenarios ever happen to you or a loved one. With over 40 years of combined legal experience, our hosts offer their unique perspectives and insights on a range of real-life legal situations.
Hi, welcome back to another podcast here at Critzer Cardani in Richmond, Virginia. I'm Jackie.
I'm Scott. Hey, Jack, what's on the docket for today?
What to do when you are questioned.
What do you mean? You can't ask questions now?
Oh, no, this is how to respond to the questions, right?
Right. What do you mean? Explain, Jackie. Come on.
So more specifically, okay, this is really about asserting your Fifth Amendment privilege, which is what? Your privilege against self-incrimination,
yeah,
right?
Exactly. Your right not to talk, which...
Do you have a right not to talk?
It's amazing. We are losing that right every day, I believe. But yes, we do have a right, fundamentally, constitutionally, a right not to talk. And why is that?
Well, and even more specifically, when do you have the right not to talk? So there's really two different avenues that you can assert your Fifth Amendment privilege against self-incrimination. There's the criminal side, right? You don't, in fact, most criminal defense attorneys, I think you'd agree, would say, don't talk in court, don't talk to the police. You can assert your Fifth Amendment privilege because anything you say, you've all heard it, anything you say can and will be used against you. So you don't have any duty to report what you have done, what they think you've done, or to answer questions about what they think you've done. They being the police.
Yes.
Okay. Of any jurisdiction, state, local, federal. Okay. But then there's another avenue that you can assert your Fifth Amendment privilege against self-incrimination. And believe it or not, it's in the civil world. Well, that doesn't make sense. How can you protect yourself from criminally incriminating yourself in a civil case?
Well, it's the same sort of thing. If you're talking about a crime you've committed, and you're talking about it in a context of a court or in front of an officer, for instance, or in front of another lawyer, all of a sudden you've put out there something you've done that there is a consequence to, and they have the power to report it. Once the knowledge is out, they have the power to report. So, this is really a difficult kind of thing that most people, it's a lost art, quite frankly, in the legal field of having the ability not to answer questions. We always have the right not to answer. And there are some federal stuff that you'll see in some subpoenas and things where it gets really quirky, and I believe none of that should ever happen. I think you always have the right not to talk, and you should have that right all the way to your grave. But
let's break it down. In a civil context, you might see this, and we see it most often in cases on adultery. And we haven't really touched much on adultery in our podcast. We'll definitely get to a podcast on adultery. But you say you receive a complaint or a filing of divorce, and your spouse has alleged and said that you committed adultery with John Smith or Jane Doe at the Holiday Inn on February the 3rd.
Or you beat her, or they beat you, or, there's an allegation of physical
or even
violence.
abuse.
Yeah,
Sure.
abuse.
Sure.
Absolutely.
Sure. That maybe you weren't charged for. And so here's the context of using and asserting your Fifth Amendment privilege. There's a lot of confusion about it. When do you? How can you? But you definitely can in a civil case. Let's say you're accused of adultery or you're accused of some crime as part of a divorce. If you don't assert your Fifth Amendment privilege at the very beginning, instead of saying, no, I wasn't with Jane Smith or John Doe. No, I was, that's an answer.
Yes.
Saying yes or no is an answer, and you open yourself up to then not being able to assert your Fifth Amendment privilege later on in those
who it was, exactly.
Yeah, and in those same proceedings later on. Okay, so you have to use it at the beginning, and then you have to use it all the way through, even when it comes to, let's say, trial. Now, maybe you've gone from just the pleading stage where it's just paperwork back and forth between attorneys, and now fast forward several months or sometimes a couple of years later, and now you're in front of a judge and you're having to answer questions again about these allegations of adultery. You still have to assert your Fifth Amendment privilege if you're going down that line. But what's the problem with that, Scott?
Well, let me ask a question. Is adultery a crime?
In Virginia, it is. It's a misdemeanor.
It's a misdemeanor. Didn't know that, did you? So, yeah, I mean, you've got to realize that you're in for the old saying, in for a penny, in for a pound. You can't be wishy-washy about this. You have to, once you assert it, it's asserted all the way through. You don't back off of it in any way, shape, or form. And where most people get there in a little bit of trouble, they want to answer something. So they feel like there's almost a pressure in these situations to give some little piece. And maybe if I give a little piece of information, they'll back off. And that just swings the gate wide open. Once you open the door, you've opened the door.
That's right.
Once you cracked, it's kind of like being outside or being inside an air conditioning. You crack the front door a little bit and that heat starts rolling in. I mean,
you can't close the door.
You can't close it.
That's it.
It's open. And so that heat's flowing through and that heat's already came across the threshold. You're done. So.
But there's a but. There's a big but.
Big.
When you decide to assert your Fifth Amendment privilege in a civil case, like we've just described, the judge can now infer that there was a negative answer to the question. So if the allegation is you committed adultery, and instead of saying, no, I didn't, or yes, I did, and you say, I assert my Fifth Amendment privilege, the judge can infer whatever negative response would fill in that blank.
In other words, he can assume almost to the point that you did it,
right?
Because you're not answering about it.
That's right.
Which again, me personally find completely offensive and against all constitutional manner. I don't even know how that's going to stand up. But anyways, it's a whole other argument. But yes, so now in statutory form in Virginia, not just case law, but now the judges are allowed to infer that negative. So really that becomes a reason not to even.
Well, why would you? I mean, if you're going to get the negative inference, what difference is it going to make anyway?
Well, I think, again, one of the things that we do so well is we're going to take a case-by-case basis. And, your facts and circumstances might be different than somebody else's facts and circumstances. So you can't really give a blanket answer to that question. It really is going to be an individual thing. And you're going to need a lawyer to walk through every step of that and why you would or wouldn't based on your facts and circumstances. So if you don't have, a good reason to do it, it may not be worth it. It may actually hurt you in the end. But, a lot of times you assert it to get out of depositions and a bunch of questions that are going to go further and further and further. And maybe there's more behind the scene than you need to, once you start answering one question, it may lead to some other things. Maybe it's better, I guess, say this. Say that the person that you committed adultery with, if they find out, it's really bad. So it's better for the judge to establish a negative inference that you did commit adultery, but maybe the person who you don't want anybody to find out who you did it with, or the number of people you did it with, or whatever. I'm just saying there could be a good reason for that, because say it's the sister. We've had, crazy stuff, and the family dynamics could be just horrific. It could cause people heart attacks and all kinds of stuff. So, families to blow up, all kinds of things. So sometimes there'll be a reason that you still want to assert your Fifth Amendment privilege and take the hit with a negative inference. Because either way, there's a negative inference.
Right.
Either way, there's a negative. It just depends how much. And I will say this. We'll talk about that, the adultery. I don't want to go down the adultery road.
I think it's important, though, to make sure that when you're in a situation like we're talking about, number one, either you're making allegations of criminal behavior against your spouse in a civil case, or you are the spouse who has been accused of said things. You should be dealing with an attorney who knows either the workarounds of the Fifth Amendment or how to properly assert the Fifth Amendment privilege. Not everybody can, not everybody will, not everybody understands the ins and outs. I mean, I had a case a few years ago where in the initial pleadings, we alleged, various counts of adultery with various people at various locations. And the attorney at the time answered on behalf of the client and denied the allegations, did not assert the Fifth Amendment privilege. Then we sent discovery, which we've talked about before, but interrogatory, so a list of questions that we can ask. Basically, as long as it's somewhat related to the, the facts of the case, you can ask the questions, and they have to answer, okay? And then, so in those answers, guess what they tried to do?
Assert their Fifth Amendment.
They tried to assert their Fifth Amendment privilege, and I had to write to the attorney and say, well, now we know better. You can't answer first and then later say, now you assert. Now you've opened the door. Your client has to answer these questions. Oh, you're right. Let me back up and let me do this. Now, if you're that client who relied on your attorney to protect you, really, and then you realize, oh, wait, you didn't tell me that. You didn't tell me how to answer this better. Now, you've really jeopardized perhaps some important pieces of the case. Maybe not. Maybe it's not going to matter at the end of the day. But I think you would rather be under the wisdom of and engaged with the wisdom of someone who understands how the Fifth Amendment works.
Yeah, and let me say this broadly. I mean, this is why we said at the beginning what to do when you're questioned or you have questions. So many of us are conditioned from childhood to answer people in authority.
Oh, sure.
And like the same thing, a traffic ticket's quasi-civil, quasi-criminal kind of thing. So, but first thing the cop asks you when he pulls you over, it's a speeding. Were you speeding? And 95% of people go, sure, yeah,
do you know why I pulled you over?
Or do you know why I pulled you over? Oh, yeah, I was speeding. Again, we've got to step back to the point of thinking about our answers and not answering.
Was it the smoke that was rolling out of my windows?
Yeah,
I mean,
exactly. Whatever. So basically what we're trying to convey to you all is when you're in a situation and questions start coming at you in a position that there's something there, regardless of what it is, you really need to seek counsel on how to walk through those questions, because so many people over my career have thought they could, through their charismatic personality or whatever it is, they think they're so used to getting away with stuff, they think they'll be able to talk their way out of it. And normally what they do is they talk their way into it.
Or into even more charges, not just the one, but sometimes even more charges. Like you're saying, get pulled over and do you know why I pulled you over? And you can maybe list something, and maybe that's not the thing that they pulled you over for. So now you've just added to the list.
Because I've been drinking. Yeah.
Because I was swerving between lanes. I mean, right, there's so many, and we're being a little bit silly and tongue in cheek, but really, this comes down to also say when you've been called in by the police at whatever level.
Or the school.
To answer questions, right? Can you assert your Fifth Amendment privilege if you've been, the police have knocked on your door and said, hey, why don't you come downtown with us? And because it's always downtown, right? They never say, let's go to the suburbs and talk about this. They always say, let's go downtown. And you go in and like Scott said, what do you want to do? You want to tell them, because the truth is what's right. And you surely if you tell them the truth, this will clear up any confusion about your potential involvement or your knowledge, or whether you were a conspirator or in some way connected to the crime that they're asking you about. But under no circumstance do you have to answer those questions.
Yeah.
And how many times do you hear it? Oh, they lawyered up.
Yeah.
What's wrong with that?
Yeah, there's always a negative inference. And I just think we as a people, I taught my kids, and everybody thought I was a jerk for doing this, especially principals, but I taught my kids when they're in school, you don't answer any questions, period, because you're not intelligent enough to answer a question at your age. So if you get pulled in the principal's office and it's, hey, Johnny, this happened, what do you know about it? And you start blabbing off, all of a sudden there's 7 crimes you committed on the way to the principal's office that you're talking about. They had no idea of. Happens all the time. I had a personal experience where there was a text message string and all this stuff, and the person who submitted the text message stream only submitted a portion of it. And of course the school go, did you text that? And of course the answer is yes, he did, but you didn't see the context of which it in. So all of a sudden there's all this trouble because the young person wasn't adept enough. And I'll say this, James Duane, an old professor at Regent University who's still there, has this great video, and I think he wrote a book on it, on the Fifth Amendment. I'd wholeheartedly suggest listening.
I think it's called Don't Talk to the Police.
Yeah.
There's like multi-millions of views on YouTube of it.
Yeah, and it's really, we were there when he did it. I was. It's been a long time. But we had a class, and we actually had the officer in the classroom, and we were going through this because we were teaching evidence. Well,
it was the first half of this video is Professor Duane talking about don't talk to cops. And the second half is the police officer saying, he's right, don't talk. And this is why.
Everybody I know who's a personal friend of mine who's a police officer will tell you, and your personal friends will say, very few crimes can be proven without the person admitting it.
Mm-hmm.
So again, when the point of this whole video, the point we're trying to get across is, look, you have a right not to talk, use it. Because quite often it's so much more important. There's a time to talk. There's a proper way to talk. All these things that we aren't taught that. I mean, our school civics has gone the way of the wind. We don't learn about these things and why we have them, why these privileges were given to us, and why this whole thing is there. Because when you don't understand it, we are taught growing up, if an adult asks you if you did it, you say, yes, sir, and you move on if you did it. That's not always the best advice, because sometimes there's all kinds of facts and circumstances that aren't being considered. And you can create a mess for your children that you think they're having integrity and doing all this thing, which they are. But because of the way the system is, especially nowadays, you can't do it. Same in divorce, same in all these things. You have to talk to somebody before you talk.
And, most of the time you don't have an attorney on speed dial that you can say, hey, they're calling me downtown. What do I do? So it's just being educated, right? It's not just in a criminal sense insofar as not talking. It's also in the civil sense. So make sure you understand how to use the Fifth Amendment privilege, or if you don't understand, call us. We're happy to talk to you. Send us an email at info@cclawva.com. We're happy to answer those questions for you and get you the help that you need. But be informed before you start answering questions, especially when it comes to persons in authority.
Like and subscribe. Have a good day.
Thank you.
We hope you've enjoyed this episode of What to Do When. For more episodes, be sure to subscribe to our podcast, and we encourage you to check our archives to listen to previous topics. Tune in next week for a new episode and some fresh perspective from Critzer Cardani.